Thank you, Acting President. I'm pleased to make another contribution on integrity matters on bills moved by Mr Davis, this time the Public Administration and Planning Legislation Amendment Control of Lobbyists Bill 2023, which seeks to do a number of things in relation to the purported implementation of IBAC's report into Operation Clara, namely some amendments to the Public Administration Act of 2004, inserting some new divisions to make some changes to the arrangements with respect to public sector boards and lobbyists and the Register of Lobbyists, and also amendments to the Victorian Planning Authority Act 2017, purportedly to implement the recommendation 4 from the Operation Clara report. I think I want to make just some broad comments initially about what things like Operation Clara in general terms are showing us about the operational effectiveness of our integrity system, and why we as legislators have important and special responsibilities to ensure that that system and that integrity system is operating effectively. And they're going to echo some of the comments that I've made in previous contributions on bills that Mr Davis has moved in relation to amendments that he sought to make to Victoria's integrity framework that we've debated in this chamber in the last few sitting weeks. Because I am a very big supporter of having a very strong integrity system in the state of Victoria. I think that ensuring that our public administration is undertaken in a way that is free from serious and systemic corruption is a matter that should be of utmost importance to all who serve in this parliament and all who believe that public administration must be done in the best interest of the public. And the sorts of allegations and findings that have been made over a series of reports from the Independent Broad-Based Anti-Corruption Commission, I think demonstrates that we have a system that is able to do its job effectively in weeding out, uncovering and making the sorts of findings of specific conduct, but also making the sort of policy-based recommendations about what action government and the parliament could be taking to improve public administration in Victoria. And Operation Clara is yet another one of those reports. And what we've seen from the government in response to things like the report of Operation Watts and in this time Operation Clara is an acceptance of what IBAC has found and a very clear acknowledgement of the need to implement the recommendations of those reports, even when they may be uncovering matters that people find difficult to read. But reading about that sort of conduct in a public report following thorough investigation from an appropriately empowered independent integrity agency, I think, is a fundamental part of what makes our democracy strong, as does having a government that's willing to do the work to legislate, to implement the recommendations. And that is exactly what we have here in the state of Victoria. We have a government that has an integrity agency, independent of the government, able to investigate matters which may cause some people connected to public administration in Victoria, and we've seen this over the life of IBAC, feel very uncomfortable about the work that it's doing. But ultimately, having those reports done, those findings made, and those recommendations put into the public domain strengthens our democracy. The challenge then as legislators is for us to consider matters that come before us on whether we think that they are the right things for us to be passing that will support that integrity framework. If we believe it's important, we have an obligation to ensure that when considering bills that are before us, we think they will be the right thing at that particular point in time to be supporting, which brings me to this bill. Because what we've seen, as I've demonstrated, is that the government does accept the recommendations and findings, accept the recommendations of the Operation Clara report. We have publicly said that we will work in consultation with relevant groups to develop a legislative, to develop a response and ensure that the concerns outlined in IBAC's report are properly addressed. So the question before us is really not one of substance or intent as to the importance of responding to the recommendations, but a question of manner or form, and whether supporting this bill at this time is the right approach to dealing with these issues. We think it's not, because we think that there does need to be proper and due consideration given in consultation with relevant parties to ensure that those 4 recommendations of the Operation Clara report are adequately and properly implemented. Because I'm certainly concerned that what we've seen now over several attempts to propose bills in relation to changes to Victoria's integrity framework from the opposition is that they have again and again and again been more interested in creating a political sideshow than getting to the heart of making sure we have a strong integrity framework here in Victoria. And all I can do as a new legislator in this place is look at what we've seen in the last 4 sitting weeks on the matters in this broad area of attempts to change Victoria's integrity framework proposed by those opposite, to do an assessment as to whether we think that this one is any good this time round. And unfortunately, I don't think that's the case, because I am concerned that the approach that's being taken by the opposition on these matters is not one about fundamentally strengthening Victoria's integrity framework, which I think should be the test, but one that's about creating political sideshows. We saw on previous bills that have been produced and inserted into this chamber for debate that people's natural justice would be denied, that bills were brought forward under the name of strengthening the integrity framework that would have sought to undermine procedural fairness in the conduct of IBAC investigations. Was there another bill that was brought forward by Mr Davis which attempted to undermine the role of the Supreme Court under the very important functions that it has in the Victorian Constitution to have an unlimited jurisdiction with respect to the matters that come before it. And then we had, in those bills, attempts to change our integrity framework in a manner that were so sloppy that he had to move his own amendments to his own bill to clean up some of the mess that he'd made. And then most recently, the attempts that have been made to refer those bills off to a parliamentary committee for further investigation, and that doesn't appear to be going particularly well either. So what that demonstrates to me is that there is serious and systemic sloppiness in the approach that Mr Davis is bringing to these matters. It does not fill me with confidence as a legislator who believes that we have a special responsibility with respect to these sorts of matters, that supporting this bill at this time in this form is actually going to be the right thing to do in respect of Victoria's integrity framework, because there's just been too many examples of where it's not. And those examples aren't historical examples. Those examples aren't from 10 years ago, 5 years ago. They're from the last 4 sitting weeks. And I've got to say, Acting President, when it happens again and again and again, there appears to be a bit of a pattern. And in that pattern of sloppiness, we don't think is where the Parliament should be placing its trust and confidence in making the important changes to our integrity framework that we believe are required. So we are whilst it's been very clear that the government takes the matters raised in the Operation Clara report very seriously, we are very concerned with the issues that have been raised, particularly with respect to the need to change guidelines with respect to the way lobbyists are regulated under the Lobbyist Code of Conduct, for changes that need to be made with respect to the role of public sector board directors engaging in lobbying activities, and then commensurately the appointments process for anyone who is a registered lobbyist to those boards, and then changes that might be required to the Victorian Planning Act to detail proceedings for a summary offence may be commenced within a period of 3 years after the alleged offence, in accordance with recommendation 4 of the report. So we do think that those are matters that do need to be addressed. The government is taking its role of undertaking the sorts of consideration and consultation that you'd expect a government that takes integrity seriously to do, and have the necessary members of our public service do that work in consultation as they deem appropriate, and to bring, when that work has been done properly, bring it back to the Parliament for particular consideration and due consideration at that appropriate time, so that we can progress these issues that are brought to our attention from the Independent Broad-Based Anti-Corruption Commission. So we will pursue these issues in a methodical and appropriate way. We will get the legislative reform right, and we won't use the integrity system as a way to score the kinds of political points or change the fundamental nature of our integrity system from one where it does do an important job in uncovering serious and systemic corruption in the state of Victoria, makes public its findings and recommendations, and that those recommendations are acted upon by a government that takes these issues seriously and are considered by us as legislators in determining whether we think that's the sort of legislative amendment that is required to take our integrity system forward. It is an area, of course, where the government in the past has demonstrated that it does have both the appetite and wherewithal to make changes to our integrity system, to strengthen the system and to make it work better. In fact, Dr. Bark talked in his contribution about the role that the previous Baillieu government played in establishing IBAC. He did neglect to go through in any detail the very, very serious amendments that were brought to this place by the former Special Minister of State in 2019, which made voluminous amendments to the integrity system to make sure that it worked properly, who made sure that it could work properly. And the consequence of that serious and detailed consideration has been a system of integrity in this state which is doing its job properly, free from political interference, free from the sorts of political sideshows that have bedevilled other jurisdictions, and capable of producing the sorts of investigations that uncover things like those matters referred to in Operation Clara, and provided sensible, concrete recommendations that the government can consider about how to improve the system going forward. The government takes these matters seriously. It is committed to implementing the recommendations of the Operation Clara report. In doing so, though, we shouldn't be distracted by the attempts to make it a political sideshow, and we shouldn't, frankly, support the attempts which, on all track record in the past, have been pretty sloppy in their attempts to make changes to the integrity framework in the last few sitting weeks here in the Parliament. So we support our integrity system. We want to make it better. We're not sure this is the right way to go. Thank you, Acting President.